What is your problem? I don't urge. Excuse me. Excuse me? What do you mean what's going on, first of all?
You get hurt, someone flagged us down and said that there was minor injuries. Are you injured?
I'm not injured at the moment, as far as I know. I need to see a doctor if I, to know if I'm injured.
Has something happened?
Am I allowed to?
Can you please keep
Am I under arrest? You're on camera, by the way.
That's great. You're on
Am I under arrest?
No. I just got
Name and badge number, please.
Where's that Adam?
Name and badge number, please.
I put more, but not.
Name and badge number, please.
You'll get that in a second.
I have a right to your name and the badge number. It's department policy.
My investigation.
I will answer I will answer your question.
We're on our way to Walmart. Okay, we're on our way to Walmart because of a disturbance.
Yes.
Okay, so then someone just said, "Hey."
This interaction begins with the familiar claim that police are present to check on safety. Yet from the very first moment, the officer's tone creates tension rather than reassurance. Instead of calmly explaining the reason for contact, the officer issues commands and controls the scene through authority rather than communication. This immediately places the citizen on the defensive, which is a common mistake that escalates otherwise neutral encounters. When officers fail to identify themselves upon request, it sends a message that transparency is optional.
You might be involved, so I don't know what's going on. I wanted to make sure you're safe.
I'm safe.
Okay.
Name and badge number, please.
I'll give that to you.
Name and badge number,
90 West
please.
Hollywood.
Name and badge number, please, ma'am.
You'll get that in a moment.
I have a right to it. It's department policy to identify.
Yeah, and I'm not done with my investigation, sir.
It doesn't mean you don't have to identify.
Yeah, how about you identify you? I'm Officer Rios, 198.
I have a First Amendment right to be filming. I have a Fourth Amendment right to be secure in my papers and not to identify to you.
You don't want to give me your information then?
Not unless you suspect me of committing a crime, in which case I would like to know what is your...
I've given you. I'm 198,
what is your,
Officer Rios.
Thank you.
I explained to you,
Okay.
you got to call
What is,
Walmart.
but what gives you reasonable, articulable suspicion of a...
Okay, can you please keep your hands out of your pocket,
Am I detained, ma'am?
Keep your hands out of your pocket, sir.
Am I detained?
Yes, actually you are.
Okay, can I ask what crime you suspect me of committing?
I'm not going to get in this battle.
Is a disturbance a suspicion?
Do you need any help?
No, I don't.
Have you been injured?
No.
Respectful engagement at the start often determines whether an interaction remains lawful or becomes confrontational. Next voice, next voice. The citizen repeatedly asks a fundamental and lawful question. Am I under arrest or being detained? This question matters because it defines the legal boundaries of the interaction. Officers are required to clearly articulate detention when it occurs, yet here the response is delayed and unclear. That ambiguity allows officers to exert control without accountability, which undermines constitutional protections. Citizens should never have to guess their legal status during police encounters. Clear answers protect both the public and the officers involved.
I don't need your help.
Walmart.
I don't need to answer your questions. Okay. I'm asking you a simple question. Is a disturbance a felony or misdemeanor?
Depends on what kind, sir.
Can you answer my question? Can you answer my question?
Yeah, actually it can be. There's varying states.
Okay, tell me what state would be a felony.
There's felony and there's misdemeanor.
Tell me what state would be felony.
We just got a call of a potential incident over there.
And was it felony or misdemeanor? I'm just asking a simple question because you're being very aggressive. You showed up being very... Yeah, you did. You told me to sit down. When you showed up, you told me to sit down.
Okay.
I don't have to sit down just because you told me to. You showed up and just told me to sit down.
The request for a name and badge number is reasonable and lawful, especially when an officer is giving directives. Department policies across jurisdictions require identification when requested, barring specific safety exceptions. Refusing or delaying this identification increases suspicion and erodes legitimacy. Transparency is not a threat to officer safety. It is a cornerstone of public service. When officers resist simple accountability measures, it reinforces the perception of unchecked authority rather than lawful policing.
That's what you said. Name and badge number, sir. Name and badge number, please.
My name is Officer Hernandez. My badge number is 294. Is there anything else I gotta be out with?
Thank you very much, sir.
Are you the individual that Walmart called about?
Is there first of Walmart called
Yes.
you?
What did
First
they
of
flag
all,
you down for?
No, they flagged me down and said they were leaving Walmart and whatever altercation had occurred there. So when I asked them, I needed to make sure.
you told me to sit down first, lady.
You're right. It is officer, sir. Okay.
It's also lady.
And then I asked you to keep your hands out of your pocket. Okay.
Do I not have a right to put them in my pocket?
Actually, no. Not when we are coming from a call of a potential violent act, sir.
Of a potential violent act, that means because you pulled up to me, you have a right to tell me to I can't put my hands in my pocket, and I have to sit down on the ground.
So here's the thing: is we got a call to Walmart saying that there was a.
The officer's repeated commands to keep hands visible highlight a common justification used during vague or unsubstantiated stops. While officer safety is important, safety concerns must be grounded in specific, articulable facts. Simply responding to a general call does not automatically remove a citizen's rights. Blanket restrictions, without clear legal justification, turn precaution into control. Rights do not disappear because an officer feels uncomfortable.
Cooperative reporting party that said that their hand was cut and was fighting with security.
Fighting with security?
Verbally fighting or whatever it may be. That's what I'm saying. So did you?
Well,
is that you?
based
You
on
cut your
based
hand?
on the way I was approached, I choose to invoke my Fourth Amendment right to our Fifth Amendment right to remain silent. Fifth Amendment right to remain silent. I'm a little agitated. She came up to me very aggressively, jumped out very aggressively, almost as if she wanted to come right at me and assault me. And then she tells me to sit down.
I'm sorry that.
Well, I have it on camera, sir.
You have your
So
ID on
in
you,
your
sir?
Do you have a reasonable, articulable
wanna
suspicion of
give
a
us
crime to expect me to identify and violate my...
It's Thornton. And can you please keep your hands out of your pocket, sir?
Okay, how about this? I will take everything out of my pocket so it makes you feel more comfortable,
Thank you.
and I'll put it in this other pocket here, so it's not in there. I understand that you have a risk of danger, but I also have rights, ma'am, and I do...
A critical issue in this encounter is the absence of reasonable, articulable suspicion of a crime. The citizen asks multiple times what crime is being investigated, yet receives only vague references to a disturbance. Disturbance alone is not a crime without specific elements being met. Law enforcement must articulate facts, not assumptions or generalized calls. Without this foundation, detention becomes unlawful, regardless of how confidently it is enforced.
I do want to put my hand in my pocket at the moment.
Very well, sir.
I don't think that's an issue. All I'm asking is the reasonable, articulable suspicion of a
I
crime.
already told you that.
What crime?
I told you.
What crime?
We told you why we were on our way to the call.
I would have been much more cooperative if you weren't very aggressive with me when you pulled up.
Okay.
Did I not pull over?
Actually, when I pulled up, I was trying to give the address to the location, sir.
I didn't know any of that. All I know is I seen what appeared to be you honking, and I pulled over.
Actually, I never honked.
Well, I didn't know who honked. I just
No
pulled
one
over
honked,
because I
sir.
heard honking.
Yeah.
Yes, someone honked. I have it on.
I know what it was. It was the people who honked at me.
Well, regardless, when it started, I was very cooperative. I pulled over. Okay?
Yeah.
You came up very aggressive to me.
Okay.
That changes how I feel about the situation now. Now I want to invoke my rights because I feel like you're immediately not on my side. You're immediately not even willing to hear anything I'm saying. I'm just immediately...
The escalation in tone comes primarily from the officers, not the citizen. Commands are issued before explanations, and authority is asserted before legality is established. This approach often provokes resistance, even from cooperative individuals. Policing based on dominance rather than dialogue creates unnecessary conflict. Professional conduct requires emotional control, clarity, and patience, especially when constitutional rights are being exercised.
criminal in your eyes. You pulled up without identifying me at all, just like, this dude's guilty.
I'm sorry you felt
I thought I was innocent until proven guilty. All of a sudden, I'm sitting down on the ground with an aggressive officer getting right in my face. I'm an officer. I don't have to identify you right now. It's not department policy to identify when asked. It's department policy to identify after the whole event is over, ma'am, when I'm not filming you with the camera. No, that's not the case. That is not department policy.
I'm not going to argue with you.
Very good at what I do in this.
If you have more information you'd like to share, I'm open to hear it.
absolutely not respectful whatsoever of a person's constitutional rights. I have to identify because you don't have reasonable articulable suspicion of a crime. You have to at least tell me what the crime is. What is the crime?
I told you why you got the call for service, sir.
But what is the crime that gives you the right to force me to identify? See, my Fourth Amendment right is to be secure in my papers.
I'm just going to go ahead and stand by. Okay? You're not injured. That's...
The citizen's invocation of constitutional rights, including the Fourth and Fifth Amendments, is lawful and appropriate. Invoking rights is not an act of guilt, nor is it obstruction. Unfortunately, officers sometimes interpret silence or refusal to identify as defiance rather than protection of rights. This misunderstanding contributes to unlawful detentions and rights violations. Citizens should never be punished for knowing the law.
Kind of what it came to be. So, you don't need medical attention. Actually, you did say you didn't need medical
I may or may not. I would need to see a doctor because I'm not qualified to make a decision like that regardless of the circumstances. I'm not a doctor. All I know is I'm being aggressively spoken to, like right off the bat without you knowing anything.
The officer's claim that identification policies apply only after an event is over is misleading and incorrect. Department policies and case law consistently support identification upon lawful request during official contact. Misinforming the public about policy erodes trust and exposes departments to liability. Officers are expected to know the rules they enforce. Ignorance of policy is not an excuse when constitutional rights are at stake.